Should it be experts working inside federal agencies, or should judges have the final word when the law is unclear? For decades, this question existed quietly in the background of American government. Most people never heard about it. They never saw it on the news. They never discussed it at the dinner table. But behind the scenes, it shaped decisions that affected almost every part of daily life. The air people breathe, the food they buy, the medicine they use, the money they invest, and increasingly the technology they depend on. Now, that entire system is facing one of its biggest challenges in modern history. Supporters say this is a historic correction. They argue that unelected government agencies became too powerful and were making decisions that should belong to elected representatives. Critics say the decision could weaken the ability of experts to protect the public in a world that is becoming more complex every single year. And that disagreement is exactly why this story matters. Because this is not just about lawyers arguing inside a courtroom, this is about how America was governed. To understand what happened, we need to go back. For most of American history, Congress has created laws. But as the country became more advanced, lawmakers faced a major problem. Modern society became too complicated for Congress to write every single detail into every single law. Think about it. How could hundreds of elected officials possibly create exact rules for every chemical used in factories? How could they personally decide every technical safety requirement for airplanes? How could they write thousands of pages of rules for financial markets, medical technology, and emerging industries? The answer was to create expert agencies, organizations filled with scientists, economists, engineers, doctors, and specialists. Congress would create the basic framework. Then these agencies would use their expertise to determine the technical details. This became one of the foundations of the modern American government. Agencies like the Environmental Protection Agency, the Food and Drug Administration, the Securities and Exchange Commission, and the Federal Trade Commission gained the ability to interpret broad laws and apply them to changing situations. And for decades, courts often gave these agencies significant room to make those decisions. The reason was simple. A judge might understand the law, but a scientist might better understand a chemical. An economist might better understand a financial system. A medical expert might better understand a new treatment. The idea was that complicated problems required specialized knowledge. But over time, critics began questioning this system. They argued that something had gone wrong. Their argument was that agencies were no longer just carrying out laws passed by Congress. They believed agencies were creating new rules with the force of law, rules that could affect businesses, rules that could create billions of dollars in costs, rules that could change how Americans live and work. And their question was powerful. If a decision has the impact of a law, shouldn't it be made by people who were elected by voters? This argument became the foundation of a growing legal movement. For years, conservative legal organizations, business groups, and constitutional scholars challenged the idea that agencies should receive automatic trust when interpreting unclear laws. They believed the Constitution created three branches of government for a reason. Congress makes laws, the executive branch enforces them, and the judiciary interprets them. The concern was that powerful agencies had started operating like a fourth branch of government, an unelected branch, a branch with the ability to create rules, investigate companies, and impose penalties. Supporters of this view said the solution was simple. If America wants a major new rule, Congress should clearly authorize it. Critics responded with a different question. What happens when Congress cannot act quickly enough? What happens when technology changes faster than lawmakers can respond? What happens when new challenges appear before Congress has written specific instructions? That debate eventually reached the Supreme Court, and when the justices delivered their decision, it immediately became one of the most discussed legal moments in years. The court's ruling changed the way judges review decisions made by federal agencies. The basic idea was that courts should not automatically accept an agency's interpretation of an unclear law. Instead, judges must use their own independent judgment. To supporters, this was a return to constitutional balance. To critics, it represented a major transfer of power away from experts and toward courts. And this is where the story becomes much bigger, because the impact of this decision is